Tortious liability. It is very difficult to give an exact definition of what tortious liability is. Lawyers and academic writers don't seem to be able to find a clear definition upon which they agree completely. In general, it is liability for harm that is caused to another person due to a breach of a duty of care. Let us now look at some important aspects of tortious liability. Some tortious liability arises from the common law and some from statute. All citizens within a particular jurisdiction have a duty of care automatically imposed upon them by the law of tort. In this way, it is very different from contract law, in which the parties to a contract assume their obligations voluntarily. For example, the law of tort in England imposes an automatic duty upon every citizen not to go onto anyone else's land without his or her permission. There is no need for any two individuals to agree privately upon this. The parties concerned mayn't have had any contact with each other at all before the tort of trespass to land is committed. In this respect, it is much the same as in criminal law. The law of tort will impose liability where a person has acted in a certain way or failed to act in a certain way if the law requires it. This means that liability in the law of tort can arise as a result of either an act or an omission. It is also possible, according to the law of tort, to be liable for the acts or omissions of another person with whom you have a certain relationship. An employer, for example, can sometimes be held liable for the acts or omissions of his or her employees. This type of liability is called vicarious liability. Most of the tort claims that are brought are based on fault. This means that the defendant has done something wrong. This fault can consist of having an intention to commit a wrong, but negligence is often enough to establish fault. Some torts are based on what lawyers call strict liability. This means that there is liability in certain situations, independent of any fault. The defendant in any situation known as the tortfeasor will be liable even though harm to the claimant happened without intention or negligence. For example, let's say a defendant keeps something on his or her land that is dangerous, such as a harmful chemical. The chemical escapes due to no fault of the defendant and causes harm to neighbors. This is called a breach of a strict duty. The defendant is liable even though he or she isn't at fault. Most torts require proof of damage suffered. In addition, the damage mustn't be too remote as a consequence of the defendant's behavior. However, some torts don't require proof of actual damage. Libel is an example of this. If I write something about someone that is not true, that person doesn't need proof of damage to bring an action against me under the law of tort.